Hello, my name's Kevin McManamon and I'm a solicitor at Geldards. I specialise in the areas of education law and in particular special educational needs, as well as mental capacity law. What I'm going to talk to you today about is special educational needs, but in relation to the current pandemic and what you as parents can expect of local authorities and what your obligations are. Now, we've got quite a bit to get through, so without further ado, I'm going to share my screen and get the relevant slides up. Which should be coming up very shortly. Gone a little too far ahead. Okay, so if we look at the title screen, I've entitled it Send Within a COVID Pandemic. If we then move to the agenda in terms of what I plan to talk through today, the first issue is parental responsibility to ensure regular attendance at school, and I'll talk a little about why I think that's important currently and the issues that I've seen are arising. I will then move on to educating a child outside of school and off-rolling, as that's been an issue that a number of parents have raised with me. We will then move on to school and social distancing, and then finally we'll look at what local authorities' obligations are in relation specifically to special educational needs and your child. So if we move on to the first issue first, which is parental obligations to ensure regular attendance at school, what I've done here is I've set out the relevant legislation. Oh, bear with me, let me bring that back. Sorry about that. There we are. Well, as I said, what I've done here is I've set out the relevant legislation. Now, that's contained within what's called Section 444 of the Education Act 1996. And as I set out here, it effectively makes it a criminal offence for a parent not to secure their child's regular attendance at a school in which the child is on roll at. Now, there is a defence, as I said here, and that's a defence if the parent can prove that there is a reasonable justification for their failure to cause their child to attend. What that looks like, I'm going to come on to, but there was a case a couple of years ago that some of you may recall being in the press, which was an Isle of Wight case, which related to a gentleman who took his children on holiday, and he argued in that case, well, they were normally attending school, they were just off for a week or two, and therefore they were regularly attending. That went all the way up to the Supreme Court, and the Supreme Court said, no, that's not right. The fact that they were off for a week to go on holiday wasn't securing regular attendance, and he was therefore guilty of an offence. So it's important to bear that in mind. Now, if we move on, I'm going to try and do that to the next slide. Here we are. Now, I said that there's two defences if the local. The first is where local authorities are under an obligation to arrange suitable homeschool transport and they're not doing so. If that's the case, then parents have got a defence. And the second one I've set out here is where the child is no fixed abode, and you can read the rest. It's not likely to be particularly relevant. If we then, so I'll move back to that, sorry. So what I would say in relation to the current COVID pandemic and how this relates is that the government in Westminster and the government in Cardiff, so in Wales, have taken two very different approaches. Generally, it's very much the view of Westminster. So for those children attending school in England, that children should be in school unless really there's justable cause. Now, that's got to be really a signing off from a GP, I would say, or if the child is self-isolating because either they have coronavirus or a member of their family does. Apart from that, it's not going to be a justification to say, well, there's a family member that should be shielding. I know that issue comes up quite a bit. Unfortunately, that in England is not going to cut the mustard. In Wales, we see a very different approach. And what the Welsh government have said is that they appreciate this is difficult times. They appreciate the concerns that parents have, and they would not expect any local authority to be looking to prosecute or issue fines or any other bullet points that are listed down here as parenting orders, education attendance orders, and ultimately prosecutions. So if you're living in Wales, it seems to me that you're going to find it easier to maintain a position that you don't want your child currently attending school because of the COVID pandemic. What I would say is that may well change depending on how long the pandemic lasts for and so forth, but it's something certainly to bear in mind. If we now move on to what I've called securing education otherwise than at school, and I've set out where that comes from, and it's section 7 of the Education Act. Now, I'm not going to read through what's on the screen because you'll be able to read through that at your leisure. Effectively, what this does is it gives a parent the power, if they so wish, to what we call off-roll their child, to take their child off school roll and effectively educate them themselves. However, that is the sole responsibility of the parent, and as I've set out here, if a child has special educational needs, the parent will need to ensure that those special educational needs are met and the relevant provision is put in place. So, for example, if a child requires speech and language therapy or occupational therapy, that obligation will be on the parent. Now, a lot of parents have approached me to ask, well, to get round potentially being prosecuted, if I off-roll my child and tell the local authority I'm going to educate them, will that get round it? And when we say get round it, yes, you're entitled to do that as parents, but I would say do not do that lightly. You need to be fully aware that your responsibility is to show to the local authority that you are providing a suitable education for your child, including meeting all of their special educational needs. So I would not recommend this decision is taken lightly in any way, shape or form. The next thing I'd like to talk through is school and social distancing, because again this issue has arisen on a number of occasions in relation to quite a few of my clients, so I thought it would be helpful to set out what the current position is. Now this is in relation to England, and you will see that specific guidance has been issued back in August. Again, the guidance accepts that a small number of pupils will be unable to attend in line with public health advice because they are self-isolating and have had symptoms or a positive test result themselves, or because they are in close contact with someone who has. Now, again, that feeds back into really the reasonable excuse in terms of a child not attending at school. For the small number of pupils who remain on the shielded patient list, they can return to school. That's the advice of the of Westminster for England, as can those who have family members who are shielding again. So that's the advice from Westminster and in relation to England. As I've said, the Welsh Government is taking a more lenient approach in relation to that. Now, the guidance anticipates that where a pupil is unable to attend school because they're complying with clinical or public health advice, the school are expected to immediately offer them access to remote education. And schools should certainly be monitoring the engagement with that. So that's very important to note that if your child can't attend school because of any of the reasons we've just mentioned, then the school need to be providing remote education, and that the guidance is clear that that's immediate. So the schools should be gearing up for that already in anticipation that for certain pupils that may well become necessary. Now, The bigger issue I'm seeing is where we've got children with really quite significant medical conditions which put them at far greater risk, and parents' concerns as to, with the best will in the world, schools putting policies, procedures in place, but actually those not being fully abided by, should we say, and therefore putting their child at risk. What the guidance says is that it expects schools to be actively engaged with parents to discuss these difficulties, and to attempt to relay parents' concerns. So if you are one of those parents, what I would certainly encourage is a positive dialogue with the school, because quite often a positive dialogue and clear communication can quite often relay parental fears. The next thing I'm going to look at is local authorities' obligations to arrange special educational provision. Now, I've set out what the legal framework is here. So under Section 42 of the Children and Families Act, that's in relation to England, and in relation to Section 324 of the Education Act 1996 in Wales. Effectively, they mirror each other, but a local authority maintaining an EHC plan in England or a statement of special educational needs in Wales has got a non-delegable duty to arrange all of the special educational provision contained within Section F of an EHCP or the equivalent Part 3 in a statement of special educational needs. This is a duty. It's a non-delegable duty. The local authority cannot say, well, we're arranging some or the majority or most of the provision and therefore we're complying with our obligation. There's a Court of Appeal authority which affirms the position, which is in North Tyneside, and that is clear. Local authority must arrange all of the provision all of the special educational provision contained within an EHCP or a statement. Now, you may well have heard that at the height of the pandemic, if we're to put it that way, there were easements that were put in place whereby local authorities' obligation and clear non-delegable obligation was actually, for lack of a better word, watered down to a obligation to make reasonable endeavours. That is no longer the case. A local authority's obligation is now absolute, and local authorities cannot use the COVID-19 pandemic as an excuse for not arranging provision. Now, it may well be because of social distancing and because of the pandemic, provision needs to be arranged slightly differently. So, for example, speech and language therapy I've seen done remotely via Teams or via Zoom or any other video conferencing facility. I have seen concerns raised by schools and local authorities in this regard in terms of safeguarding. However, it seems to me the most sensible thing in that regard is to have those sessions recorded, and that protects both the child and it protects the therapist. So if that is suggested to you as a concern, then just suggesting to record it may well be a way of dealing with that. Alternatively, and parents don't have to, but if parents are content to sit in during those sessions, and that's another way around it potentially. Equally, what I would be saying is if children are now returned back to school and that provision's been provided via video conferencing in school and so forth, then I would be saying this, if there is a safeguarding concern and so forth, then the school should be arranging a member of staff to sit in on that, and it may well be that that's regarded as what we call a reasonable adjustment under the Equality Act. What do you do if the local authority isn't arranging all of the provision within your EHCP or your statement? Well, ultimately, the child has the right to bring High Court proceedings, known as judicial review, against the local authority, and I've acted on a number of cases where the child has done just that, acting through their parents as what we call litigation friends, and require the High Court to provide what we call a mandatory order, ordering the local authority to arrange the provision. Now, in my experience, the mere threat of that to a local authority should ensure that they arrange the provision really quite quickly. And the reason being is potentially there's legal aid in the child's own name to bring such proceedings, and those proceedings ultimately, if the child succeeds, can be very expensive for the local authority in terms of their legal costs. It's rare that those cases go to the High Court, but sometimes they do, and it's important to know your rights and your child's rights. If it's not being arranged, then ultimately what needs to happen in the first instance is what we call a judicial review pre-action protocol letter is sent to the local authority. That will generally or usually give the local authority 14 days to confirm that it will put in place immediately the provision, and if it fails to do so, it fails to respond, then the child can look at going off to the High Court and issuing proceedings. If you are at that stage, I would suggest that you get legal advice prior to issuing of any proceedings. Now, if we move on to the local authority's obligations to arrange special education provision continued, as I've called it. Again, as I've said here, just like there was an easing, or some people have referred to it as a watering down of the obligations to arrange provision, equally there was an easement in terms of the timeframes that local authorities had to comply with various aspects of the EHCP and statementing process. Now, most of you will be familiar with that process, but by way of a very quick overview, the first stage is to request a statutory assessment. Generally, the local authority then have 6 weeks to make a decision as to whether or not they will agree to carry out a statutory assessment. If they agree to carry out a statutory assessment, in Wales they have 10 weeks in which to do that and inform the parents of their decision whether or not to write a statement, and they must then send that out. If they decide to write a statement, they must send out a draft within 2 weeks of that, and ultimately send out a final statement within 8 weeks of that. In England, it is simply just a 20-week process. Now, the easements, again, placed onto local authorities, effectively stated that local authorities must use a reasonable endeavours duty to comply with those timeframes, and that was it. However, that is no longer the case. Those deadlines are now back in force, and I have seen a number of local authorities trying to argue that they don't have to comply with them right now. That is not the case. As I've set out here, from the 25th of September, the easements are no longer in force, and the local authorities must be complying with their obligations. I've heard of one local authority who issued a draft EHCP and then went back and said, oh no, we're going to go back to the start of the statutory assessment process again. In my view, that's unlawful. They can't be doing that. So it's very important that you're aware of that, so that if your local authority does attempt to rely on these easements or does attempt to take longer, then you're aware of you and your child's legal rights, that they can't do that. Now, what I would say is a degree of pragmatism should be exercised, in that if the local authority says, we've got a number of cases at the moment, we will have this out to you within a week, or we'll have this out to you in 2 weeks, as long as they comply with that and they give you a date by which they'll do it and they do it, then it seems to me that that degree of pragmatism will be fine. Anything longer than that, then I think pressure needs to be placed on the local authority to actually comply, because ultimately it's your child that's being prejudiced by their failures to comply with their legal obligations. And I accept that the local authorities are under a huge amount of pressure at the moment, totally accept that. However, equally, the law is the law, and your child shouldn't be prejudiced as a consequence. Now, that's been a very quick overview of the current position. I do hope it's been of assistance to you all. and I'm going to put my camera back on just for me to say thank you so much for listening. I'm very grateful. If you have any questions, please get in touch with the Nystagmus Network. They have my details, and I'm more than happy for any queries or so forth to be passed on to me. And lastly, I hope you enjoy the other sessions and the rest of the day. Thank you.